So good afternoon, everyone. My name is Joanna Cohen. I'm the director for the Institute for Global Tobacco Control here at the School of Public Health, and I want to welcome you to our monthly Innovations in Tobacco Control seminar. And I am particularly pleased to introduce today's speaker, Clara Brillembourg, and she's a partner in Foley Hoag LLP in their international litigation and arbitration practice. So she's a lawyer. She has her BA from Harvard College and the JD from Yale Law School. And I have to say, her CV is truly impressive. I don't know how she's actually done all this. I'm looking forward to hearing about that. But she actually, represents sovereign states in various disputes. And pretty much around the world. I mean, she has done work in Latin America, obviously around the US, in Southeast Asia, I think Eastern Europe, so covering a broad range of areas for sure. And she has argued cases in front of the International Center for the Settlement of Investment Disputes, also the International Court of Justice, and the International Tribunal on the Law of the Seas. So, among others. So covering a whole range of types of disputes and arbitration. She is the co-chair of the Meridian International Center's Rising Leaders Council and an advisory board member of the Harvard Kennedy School's Carr Center for Human Rights Policy. And she's worked in the World Bank as well. So I think I want to give Clara enough time to talk. She's going to tell us about her experiences representing Uruguay in their, I don't know if we call it a case, so my legal terminology is all off, but in the dispute with Philip Morris. So I think I won't say more and hand it over. Thank you so much for being here.
Thank you. Thank you for that fantastic introduction. I'll have to come back more often. I was planning on introducing myself, but you have that well covered. So I'll move on to the topic at hand. I will be discussing the intersection of international investment arbitration and public health, and specifically in this case, focusing on a state's ability to regulate tobacco. The impact of international arbitration on tobacco control is a relatively recent phenomenon, so it still has very unknown consequences and has raised a lot of questions, a lot of concerns, which I'll be bringing up today, and we'll be happy to discuss further in the question and answer period. I'll be talking about it specifically through the lens of the case brought by Philip Morris International against Uruguay, where I represent the Uruguayan government, which is the first investment arbitration case to concern tobacco control regulations, and specifically to challenge the tobacco control regulations. And it may be that this is the new battlefield for the international tobacco companies, which are so familiar and use domestic courts as part of their business development strategies. And the question is whether the battleground, which is so well worn in domestic courts, is now going to be expanding into the international arena, or whether we'll see in this case and others, it represents a dead end for the tobacco industry. So watching this case and any others that may or may not follow will start to give us that answer. So as I said, this is a relatively recent phenomenon. There have been, to date, 4 cases involving trade and investment arbitration concerning tobacco control regulations. The first one was brought before the WTO by Indonesia against the United States, in which the United States had banned the use of flavored cigarettes. But Indonesia pointed out that that ban included a major exclusion for all menthol cigarettes. Of course, Indonesia was the most major producer of clove cigarettes, and the U.S. was the most major market for them. And the United States was the most major producer of menthol cigarettes. So Indonesia actually successfully argued before the WTO that this was a discriminatory policy which did not reasonably establish this exception basically for domestic interests. Many years passed, and of course that was a case between two states. And then Philip Morris brought the case, which we'll be focusing on today, against Uruguay. This was the first case in which the tobacco companies themselves brought a case directly against the government, challenging its regulations. And that was and is before the International Center for the Settlement of Investment Disputes, known as ICSID by its acronyms. That case was followed shortly after by another subsidiary of Philip Morris International suing Australia in investment arbitration for its plain packaging regulations. That case was recently in December decided on jurisdiction. The tribunal found that it didn't have the power to even pronounce on these issues because, in simplistic terms, Philip Morris had gone forum shopping. They had moved the investment to Hong Kong on the eve of bringing this case. The tribunal found in order to bring this case and therefore found that it was not a valid dispute brought under the treaty. And accompanying that case is a case before the WTO, again challenging Australia's plain packaging regulations, in which 5 states, and you'll see I've crossed out Ukraine because happily last year with the change in administration, Ukraine decided to withdraw its claims. And there is uncontested evidence that the tobacco industry has been very supportive and even financially supportive of the legal fees, et cetera, involved in these 4 states bringing this case. And the WTO case is ongoing against Australia. So before I keep going, recognizing that I'm not talking to a room full of lawyers, I wanted to just quickly lay the foundation and take a step back, explaining what investment arbitration is, what trade disputes are. Investment arbitration is an arbitration based on investment treaties in which 2 states enter into what's called a bilateral investment treaty. It can be multilateral, it can be multiple states, NAFTA being an example, in which they offer certain protections to the investors of the other states. The first, what's called a BIT, was entered into in 1959, and since then, and particularly in the 90s and in the last decade, there's been a huge proliferation where now we have over 2,500 of these bilateral investment treaties. Many of which were done in a period where countries were trying to foment economic development between the 2 of them, and would use the treaty kind of as a photo op treaty. When a minister came to visit, that would be their way of showing their positive economic collaboration. Of course, this was more than a photo op because the treaties built within them this investor-state dispute settlement provision, which allows the investors of the other state to sue that host state if that state doesn't live up to the specific protections offered under the treaty. So this, of course, allows for foreign investors for the first time to sue states for regulations, for policy changes. The most frequent forum, although not the only one for these disputes, is ICSID. And the outcome is almost always, nearly always, monetary compensation or damages. And again, I'll get into that in the case of Philip Morris versus Uruguay. Now, contrast that with a trade dispute, which is a totally different animal. The trade disputes are brought before the WTO, which was born in 1995 from the Uruguay round of multilateral trade negotiations and is based on the understanding on rules and procedures governing the settlement of disputes, which allows for dispute resolution between member states concerning only a certain list of treaties. And a prime example that's often mentioned is the TRIPS treaty, which protects intellectual property rights. So the outcome in these WTO disputes is, first of all, there's a major emphasis on getting the states to agree between themselves and to work out a solution. And that's why this system was created. They were tired of states taking unilateral actions as reprisal for another state's economic activities. And they wanted to create a forum in which they could resolve these issues in a more kind of amicable and less and avoid the trade wars that had been happening for so many decades. So they really put a lot of emphasis on mutually agreed solutions, where adjudication, the actual disputes, is a last resort. However, if you do get to the dispute resolution stage, if a party is successful, the outcome is usually the withdrawal of the measure that was implemented. So in this case, in the Australia case, could mean withdrawal of the plain packaging regulations. And if not withdrawal, then the states work together to figure out whether it will be based on compensation, financial compensation, or countermeasures, a little tit for tat between the two states. Okay, if you continue doing this, then we get to put in force these regulations, which are also not very compliant with the WTO rules. So traditionally, or historically, these three worlds were ships on far apart oceans. They went about their business: investment arbitration, trade disputes, public health, and tobacco control. Each were in their own worlds and didn't have much to do with one another. And that's surprising for a lot of people that conflate trade and investment. It's two completely different things until now. And now we're starting to see, because of these tobacco cases, an intersection between the two. So what has happened is, now that these three disparate worlds have met, there are new tensions, new questions, new concerns that are coming into it that are being voiced and manifested through these tobacco control cases. So what happens is, you have these commitments made under these bilateral, multilateral investment treaties, which offer certain protections to foreign investors, including tobacco companies. And you have this ISDS, this investor state dispute provisions that allow for these investors to bring cases when their investment is being harmed, aka selling tobacco products. On the other hand, you have these other public health commitments entered into international treaties and in domestic frameworks, like the Framework Convention on Tobacco Control, which is, I'm sure you all know, a very unique treaty, the first of its kind for the first time the WHO has hosted an international treaty, calling attention to the unique nature of tobacco and and the unique risks that it causes. You also have the more broad-based international human rights treaties, which provide for more general public health obligations and obligations for states to protect their citizens from certain harms. And then, of course, you have the domestic constitutions and public health legislation, again, calling on states to protect their citizens. So on the one hand, states are now being called to uphold these commitments, and particularly the FCTC calls for much stronger and more forward-looking measures that have been done in the past, and are really looking for states to put forward the next generation of tobacco control if they're at that stage. And then on the other hand, you have these investor protections offered in the BITs and multilateral treaties. And so this insertion of these public health commitments into the ISDS context has raised important questions in investment arbitration, which it never truly had to face before, although they'd always been lurking. And the question is, are these other commitments, be it human rights, be it public health, be it tobacco control, taken into account in these investment arbitration disputes? And the name says it all. And are the mechanisms to take them into account sufficient? And if they are not sufficient, what are the limits, and how do we reform the system to better allow for these other state commitments to be considered when a tribunal is determining whether investment protections have been violated or not? Because states are unsure of the answer to these questions, we've seen that they're taking both defensive and offensive action. Defensive action, unfortunately, either as a result of direct threats from the tobacco companies against states contemplating tobacco control, or because the states have been watching Uruguay and Australia, and more Uruguay, a small state with more limited resources that a lot of other states sympathize with their circumstances. Some states are deciding not to move forward, and it has had a certain chilling effect on tobacco control in some places because of the risk or the threat that they could face the same fate. On the other hand, you have a lot of states who have gone on the offensive and say, you know, we have a sovereign right to protect our citizens, and not only a right, but a duty to do so. And this is literally a matter of life and death, and we will not be cowed from doing what it is that we need to do. And so what instead they're doing is that they are taking a hard look at these commitments that they're entering into an investment treaty and trade treaties, and reforming those treaties to better account for these other commitments. And one prime example, and happy example, depends on who you ask, of that is the TPP, the Trans-Pacific Partnership. Very recently, many of you may know, included a provision that excluded very explicitly tobacco control measures from being challenged in the investor-state dispute system that was included in the TPP. And the TPP, of course, represents, I think it's, I may be wrong on this, but 40% of the world economy, or it's a big deal. And it's going to affect a lot of trade relations, and a lot of countries also may be joining in. So it is an important precedent, which have made a lot of states stand up and pay attention. But having said that, we know that this tension, these questions are going to continue to arise and develop because, as I said, the FCTC was entered into force, I believe, in 2005. And we see that states are continuing to strengthen their tobacco legislation. Australia is being sued for their plain packaging, but we also see that Ireland, New Zealand, even France is contemplating plain packaging along with the UK. And we also see that many countries have put in place much larger warning labels, which we'll get to the Uruguay case in a second, where they've surpassed Uruguay's 80% warning labels and have gone far beyond it. So while states are continuing to increase their tobacco control regulations and get even more aggressive, we also see that many of these treaties, including the FCTC and others that I've mentioned, they lack a dispute resolution mechanism. So any tensions or disputes that arise out of these regulations are likely to continue to be funneled through these bilateral and multilateral investment treaties, which have very clear and strong dispute resolution provisions. So how do we see this manifested in the specific case of the Philip Morris International versus Uruguay? First of all, I should say it's not called Philip Morris International. It's called the names of the 3 subsidiaries of Philip Morris International versus Uruguay. 2 of them were Swiss subsidiaries, and 1 was the Uruguayan subsidiary. The case was initiated before ICSID, as I said, in February 2010. We just had the merits hearing in October of last year and are eagerly awaiting the decision. Uruguay, it took a little longer because Uruguay did contest jurisdiction, but the tribunal found that it could continue to assess the case. As I've mentioned, it's the first investment arbitration concerning tobacco control. It was the first investment arbitration for Uruguay, and as I've noted, for many countries, they've never done investment arbitration. This is an unfamiliar, unsettling ground for them, and a threatening letter from the tobacco industry saying, we know we are right and we will beat you, can have pretty compelling effects on a government that has no familiarity with the laws, the statutes, the doctrine. I mean, there are no laws and statutes, I shouldn't say that, but the jurisprudence and the principles that apply in investment arbitration. And To date, it is the only investment arbitration concerning tobacco control to reach the merits. So for many reasons, it's a fascinating lens to look through in evaluating these larger issues. So what was Philip Morris so upset about? Why did they decide to bring this historic dispute before ICSID and against a country of 3 million people? There were two regulations, so I should say, Uruguay ratified the FCTC in 2005 and immediately began to put in place a suite of tobacco control regulations, really taking an informed and active approach to tobacco control in the country. So they passed a package of tobacco control reforms over time, which continues now. But Philip Morris was really upset about two regulations in particular. The first was what I have here, the 80% health warning label. I've noted the FCTC many times. Frankly, that is the core, the foundation of so much of this. The FCTC said that warning labels should be 50% or more of the tobacco product packaging. And Uruguay had implemented 50% warning labels shortly after subscribing to the FCTC. Later, the implementation guidelines for the FCTC were released and were much more clear in their guidance of how to implement that measure, and specifically stated that the warning labels should cover more than 50% of the principal display areas, and in fact should aim to cover as much of the principal display areas as possible. And it explicitly said that it was based on the fact that the evidence had consistently shown that the larger the warning label, the more effective it was in getting the smokers' attention and informing them of the risks and really helping them become conscious of those risks. So having heard that call and done its own evaluation, Uruguay was the first country to go above 50% of the package. Philip Morris clearly saw this as a bad precedent. It was, I would say, it's a big question whether it was really concerned about the money it could lose in Uruguay. As I mentioned, and this comes up again later, Uruguay is a country of 3 million people, where 20% at the time smoked, of which 20% of those smokers smoked Philip Morris products. So you can see how in the Philip Morris's larger bottom line, Uruguay figured into that equation. But it was clear, and there was a press article, I believe in the New York Times, where the CEO of Philip Morris International interestingly said that they thought that 50% of the package was reasonable, but that anything beyond that was not, which is of course interesting given the historic position that the Philip Morris and other companies have taken in domestic lawsuits. And specifically last year, the tobacco companies sued the United States for trying to implement 50% warning labels. But luckily, as I noted, many states have not been cowed and have seen that the FCTC and the evidence that backs it truly does merit larger warning labels. And now we have, since Uruguay broke that glass ceiling, 59 countries now have warning labels that cover more than 50% of the package. As I said, Uruguay's was 80. I know that Nepal, for example, now has 90% of both the front and the back covered. The second measure was the single presentation requirement, and this takes a little bit more explanation. It's less of an obvious give. So as the public became better informed of the dire and deadly health effects of smoking in the 1960s and 70s, the cigarette industry, as this will be old news to many of you, came out with an alternative product. Instead of quitting, they said, try this lighter version of the cigarette that you so love. And they termed these quote-unquote light cigarettes, the health industry referred to them, the tobacco industry referred to them as health reassurance cigarettes, because they were meant to reassure the consumers that they could continue smoking but choose the healthier option of these light cigarettes. In the last decades, of course, it's become clear that these quote-unquote light cigarettes are no less harmful than the original full-flavor cigarettes. And in fact, it's been recently confirmed that light cigarettes are in fact more harmful than their original full-flavor cousins. So as a result, many countries, including the US and Uruguay, have banned the use of deceptive descriptors like light, mild, soft, etc. To the surprise of, I found many of my friends who happen to also be smokers, that they didn't know they weren't smoking Marlboro Lights anymore, because the tobacco industry was so adept at seeing that this ban was coming that they associated these deceptive descriptors with colors, so that Marlboro Lights became gold, Marlboro Ultralights became silver, mild blue, et cetera, et cetera, et cetera. So what they did was, and what I have here, is that they created a spectrum of stronger, lighter, more or less harmful cigarettes, or so they were marketed, within the same brand family, with the message that, you know, if you like Marlboro Reds but you want to take a healthier choice, try Marlboro Gold or Silver. If you like Marlboro Blue but are still trying to go healthier, try the Silver or Green. So that when the consumer sees the family, when you see this family and the rainbow that it represents, you immediately know where each pack falls in the health spectrum of that family. And so Uruguay knew, you know, we banned descriptors. That was effective, but it didn't quite cure the illness. And if we ban numbers, they'll replace numbers with something else. And no matter what it is that you specifically tailor and ban, the industry will find another kind of system of creating a hierarchy within the family, because that is the brand family is where their strategy lies. And so Uruguay went to the heart of this and did away with the brand family. It says, if you would like to sell you can only sell one brand per family, one kind of Marlboro. If you want to sell a different cigarette, sell a different cigarette and sell it under a different brand. Don't present it as a different version of a given cigarette, where you're automatically, any consumer is going to do a comparison between one and the other. And that comparison, historically and primarily, had been on a health premise. Oh, no, backwards. Let's see. So, what claims did Philip Morris International bring against to challenge these two regulations? These are pretty typical claims in investment arbitration. They're just being applied in an atypical context. The first was the fair and equitable treatment. Self-explanatory, one would think, although when you have to sit down and really define what that means, it starts to get hairy, as you can imagine. Philip Morris International argued that these two regulations were unreasonable, unfair, and inequitable. And what that meant was that they were unreasonable, or in their minds, arbitrary. And so what that meant is that Uruguay was in the position of having to argue that these measures were not arbitrary, were not unreasonable, and that there was a logical connection between the regulations and the public health objective they were trying to achieve. So how does this manifest itself? It means that Uruguay and its public health authorities, who are known throughout the world as being some of the most informed and most sophisticated tobacco control experts in the world, were called to convince 3 lawyers who specialize in international law, some more in public international law, some more in commercial or investment law, that these were good, reasonable, not arbitrary public health measures. And of course, these arbitrators do not hold themselves out to be public health experts. Philip Morris also argued that, that their investment had been indirectly expropriated, that the regulations had taken away their trademarks and the value of their investments. There's two kinds of expropriation. There's direct expropriation, where the classic example where the government goes in and literally takes a factory, takes a business, takes property. Then there's indirect expropriation. That's what was at issue here, where a regulation affects an investment to such a degree that it's rendered to have almost no value, as if it had been taken, as if it were tantamount to a direct taking. And that's what Philip Morris argued here, that the regulations had indirectly taken away the value or their actual ability to use trademarks and the value of their investments more broadly. Uruguay argued that public health measures of this kind are fundamental to the police powers, to the police power. I'm trying to use a non-legal term here. It's the central pillar of a sovereign state, and it's the kind of regulation, along with security, for example, that is not compensable, that you can pass these laws without having to compensate someone who suffers a loss as a result. And that public health is a classic example of that. And that, frankly, even if it didn't fall within these fundamental police powers of the state, there was no expropriation for a variety of reasons that I won't bore you with. Then they claimed that the measures had unreasonably impaired their use of the investment. This was largely it was 100% reiteration of the arguments that they made under FET, that these were unreasonable and arbitrary regulations. The next one is a little more complicated. They basically argued that these two regulations had violated domestic Uruguayan intellectual property law because it had taken away their, quote, right to use their trademarks. And I have umbrella clause here because that's what's referred. They incorporated Uruguayan IP law into an international treaty. And again, this is international law, not domestic law, so it's not, normally one is not evaluated in the other. They incorporated the Uruguayan IP law into the treaty through what's called an umbrella clause, which is a clause that more or less says that the states promise to guarantee any commitments that they've entered into with regard to investments. There's a lot of controversy around what that means and what the scope of umbrella clauses. There's more consensus that this would, for example, incorporate a contract entered into between the government and the investor on this specific investment. In this case, Philip Morris was extending the scope extremely broadly to also incorporate any domestic laws passed and specifically done through the trademark registration. So there were multiple levels of argument, but for the sake of being brief and not too lawyerly, I'll say that what it comes down to is that, frankly, there is no supposed right to use a trademark, either under Uruguayan IP law or under international IP law. And we may see this also explained and discussed in the WTO case brought against Australia, and that's where these two cases overlap a little bit. Their argument was that the minute you register a trademark, that it gives some sort of guarantee to be able to use that trademark, but anyone with any common sense or familiarity with the area knows that a trademark registration says that, okay, you have this trademark, nobody else can use this trademark but you. But that doesn't mean there can't be regulations on how you can use the trademark, on the kinds of trademarks that you can use, or even bans. I mean, as we saw, Marlboro Lights was banned. That I'm not an IP specialist, and there are arguments about whether lights is a trademarked word, but point being that trademarks can be banned, can be regulated and limited. There is no supposed right to use that functions as a kind of guarantee for use or compensation if a trademark is limited. Those were the four claims brought against these two regulations with a kind of belt and suspenders approach. Philip Morris also brought a separate claim that, that the Uruguayan courts had denied the Uruguayan subsidiary ABAL justice when ABAL had brought claims against these same two regulations in Uruguayan courts under Uruguayan law. And they argued that for very specific reasons, that they felt that those domestic proceedings had constituted a denial of justice, but those didn't question the regulations themselves. So what was the end result that they were seeking in having done this? Well, the larger end result is something that I'm happy to discuss more, very within the confines of the arbitration. They were requesting, one, that the tribunal revoke the measures, or I should say that the tribunal order Uruguay to revoke the measures, which Uruguay adamantly opposed, saying that the tribunal does not have the power to order a sovereign state to rescind its own regulations, and in this case, particularly public health regulations. And moreover, it's entirely inappropriate for a tribunal to be telling a state what laws it can and cannot pass. So Philip Morris wanted them to revoke the measures and pay for any interim losses suffered. If offering an alternative argument, Philip Morris said that Uruguay could pay losses in perpetuity, keep the regulations, but pay losses in perpetuity, amounting to $23 million. And $23 million is certainly a lot of money, and is certainly a lot of money to the government of Uruguay. In the world of investment arbitration, this is pennies to a pound. Investment arbitration involves hundreds of millions of dollars. My firm is representing states in several disputes right now that involve hundreds of millions, if not billions of dollars. It's also pennies to the pound in terms of Philip Morris's own revenue. I have some fun stats to put this in context. Philip Morris in 2013 made $80.2 billion in revenue, compared to Uruguay's entire national GDP, which was $55.7 billion. So the chairman of PMI makes $17 million a year. So these damages would basically pay for one official's annual salary. They also threw in that Uruguay should in fact have to pay the legal fees and arbitration expenses of Philip Morris International. Unfortunately, because this is one-sided, Uruguay, in countering the demand, says, the tribunal should deny revoking the measures, should deny the request to pay compensation, and Uruguay feels strongly that that Philip Morris International should have to pay the legal fees and arbitration expenses for Uruguay, because we have seen in the evidence, and unfortunately it's confidential, some of it is, although some of it is public and supports the fact that this case was used as a PR campaign. Do they want the $23 million? Of course, sure. Did they want to revoke the measures in Uruguay? Of course they did. Did they want to use Uruguay as an example for other small states, small countries considering the next generation of tobacco control, and show what consequences could come if states, tried to follow this similar path and specifically tried to implement the same regulations? We've seen that the warning labels have taken off. The single presentation requirement hasn't had the same trajectory, although other states have seen the complement in the form of the plain packaging regulations passed by Australia and hopefully soon others. So what's the takeaway message here? First, and most importantly, have no fear. The tobacco companies have no case, and they know it. So long as these regulations are enacted in good faith and are backed by evidence in an informed process, then there's no problem. There is no violation here. And the evidence is overwhelmingly in support of the tobacco control measures, and particularly in the tobacco control measures noted and called for under the FCTC, which is why the FCTC is such an important and revolutionary instrument in allowing the states the legal backing that it would otherwise have, but would be more difficult for every 200 plus states to compile individually to be able to present their case. I would also like to point out that for lack of a better word, trade community or investment arbitration community is acutely aware of the consequences if Uruguay were to lose this case. This case, as you and the audience are here as a testament to, has become kind of a poster child for some of the concerns and critiques that people have about the investor-state arbitration process. And so long as this evil poster child is out there, it gives more power to those critics and gives more weight to those questions. So if Philip Morris were to win, it would really kind of not kill, if not harm, the goose that lays a golden egg for all the people who are involved in investment arbitration and make their living that way. And there's also, of course, the international public health community, which has been overwhelmingly in support of the regulations that Uruguay passed and similar ones passed throughout the world. Specifically in this case, the WHO and the FCTC Secretariat, for the first time ever, presented an amicus brief in an international dispute, basically fully supporting Uruguay's measures. The Pan American Health Organization also presented an amicus in support of Uruguay. Funding was some funding was provided by Bloomberg Philanthropies to help Uruguay support some of the legal costs which were involved in taking this case on instead of backing down. And in fact, Bloomberg and the Gates Foundations have now set up a permanent fund to support any state that is faced with international arbitration or litigation concerning tobacco control. And of course, the case could not have happened without the technical advice of the Campaign for Tobacco-Free Kids. You can imagine, I feel comfortable speaking to you now, several years in, but when this case first started, we were not experts in tobacco control, in the history of tobacco regulations, in the history of tobacco marketing, in the thousands and thousands of documents in the legacy database supporting the deception that they had perpetrated over time and supporting how they manufacture the cigarettes. So there was a very steep learning curve that we had to climb to really understand in its core the strategy used by the tobacco industry and the reasons behind these regulations and the evidence supporting it. And the Campaign for Tobacco-Free Kids was critical in helping us very quickly run up that slope. And of course, there are the states who have continued taking action around the world, showing that Uruguay may have been the first, but that it was quickly followed by many behind it. And the best good news message, and why you should have no fear, is because these regulations really matter, and they have an effect, and they are worth the struggle, the costs, the litigation that they brought. In Uruguay, specifically, the SPR, the single presentation requirement, was passed in order to get rid of this deception around light cigarettes. What we saw was that before the SPR, 29% of the public, of smokers, not the public, thought that light cigarettes were in fact less harmful for you than the full flavor cigarettes. After the SPR, we saw that dramatically drop to 15% of the public, of smokers. More smokers after SPR also understood and agreed that light cigarettes are not less addictive and that they are not easier to quit. In terms of the warning labels, the ITC survey in Uruguay, which was also extremely helpful in this case, and shows the power behind statistics, behind numbers, behind evaluating the impact of public health regulations and really following them from the start to finish. If we hadn't had that, it would have been much more difficult, and that is where the public health community can really do a huge contribution, provide a huge contribution to strengthening the state's position. All of the measures for the effectiveness of health warnings increased when they, so here we have 50% health warning labels, and here we have the 80%. So already at 50%, we saw some increases, some improvement, but you really see the change from 50 to 80%, where across the spectrum, from noticing them to begin with, but noticing is not enough. Most smokers know that cigarettes are bad for you. It's a question of really internalizing and personalizing those risks and turning that into action. And so again, we saw on the other factors of actually making smokers think about the health risk, of making them think about quitting, and of actually changing behaviors in increasing, and you can see here a dramatic increase of smokers avoiding looking at health warnings, which is actually a positive sign. It means that the warnings are having an impact on their thinking. And in fact, on smokers who actually gave up a cigarette specifically because of the health warning labels. The best news of all, and where I'll finish, is on smoking prevalence in Uruguay. Uruguay had some of the highest smoking rates in the Western Hemisphere. At one point, 40% of the population were smokers. Before the FCTC was ratified by Uruguay, a third of the population were smokers. After the FCTC and in 2014, after SPR, after the 80% warnings, and after the other suite of reforms that they implemented, that dropped down to a quarter in 10 years. That's a huge change. But the grand finale, the most amazing change that we've witnessed from the Uruguay's active tobacco control policies is the adolescent prevalence. In 2003, 30% of teenagers, 1 in 3 teenagers, smoked cigarettes, and as you may already know in this room, that is the lifeblood and the future of the tobacco industry. In Uruguay, as in all other countries in the world, people start smoking. Most addicted smokers start smoking in their teenage years. If you make it through to adulthood, you are very unlikely to become an addicted smoker. In Uruguay, I believe the starting age is 13 years old. For the majority of smokers. So if you can affect the teenage smoking rates, you can affect the future of tobacco consumption in Uruguay and of the people who suffer the illnesses and deaths as a result. 2003, 30%, 2014, 9, single digits. That's incredible. And that just from, in a short number of years, dropping it from 30 to 9. I mean, 9 is the death knell for, if we can keep it there and continue to lower it, is the death knell for the future of smoking in Uruguay. And Uruguay is continuing to pass regulations. It recently, last year, passed a regulation banning the display of cigarettes in the points of sale. So when you go up to buy a piece of gum, you're not, a 17-year-old isn't going to also see a cigarette and wonder, do I want to buy one? And a consumer also has to, you look at a list, a smoker also looks at a list of cigarettes and says, I would like that one. There's no attractive, prominent display of the cigarettes for the 9% left who might be enticed. With that, I say thank you. If you didn't sleep through my presentation today, there's a much more entertaining version of it, done by John Oliver, if you hadn't seen it already, talking about how investment arbitration and tobacco control have found each other. So I highly recommend that to you if you found this at all interesting, and I'm happy to answer any questions you might have.
Thank you so much. Very interesting and puts a lot of very timely perspective on the broader sort of social and political context around our work. I'm not sure, I might be conflating the trade agreements and the investment disputes, but I was wondering if you could talk a little bit about if any mechanisms exist in investment disputes as there are in trade disputes that specifically protect public health. So if I remember correctly, the WTO has this provision in the GATT or something where there's a specific protection for laws that are meant to support public health measures, and is that considered directly in investment disputes as well?
Sure. So yes, in the WTO, what you're referring to is Article 20 of the GATT, which provides an exception for measures meant to protect life, animals and plants, I believe. Measures necessary, I should add, as a lawyer, to protect those things. So that's an important, though every word in a treaty matters, and the necessary means that you need to prove to the WTO panel that these, in fact, regulations are necessary to meet those objectives. But it is a very important exception. In the investment arbitration context, each investment arbitration is founded on the specific investment treaty which provides for jurisdiction in that case. So here it was the Switzerland-Uruguay treaty. One of the jurisdictional objections that Uruguay brought is that there was a provision in there that should be read as an exception for public health. But the wording was such that the tribunal found that it wasn't, in fact, an exception. So it depends on the specific provisions and specific wording of the bilateral or multilateral investment treaty. As I said, many of these were signed in the 1990s, where you kind of had a dynamic of capital exporting versus capital importing countries, and so there wasn't as much consideration of that. As treaties have continued to evolve, we see many more of these model investment treaties by the US, Canada, Norway, others, starting to incorporate provisions which better protect not just public health, but also the state's ability to regulate in the public interest. And that's continuing to evolve on a daily basis, and that's a large topic of conversation within the investment arbitration world.
Well, maybe I'll just ask, you mentioned that you're awaiting the ruling of the tribunal, and is that the last step, or could there be additional steps? How does all that, and when are you expecting to hear?
Is it the last step? Hopefully. Hopefully if we win. So it's final. The award is final and binding. In the ICSID system, the only way you can contest the award is not through an appeal, but through an annulment, which means there has to have been a manifest disregard of the law to an extreme level. It can't just, there's a lot of dispute about what it means, the standards for annulling an award, and whether it can be an error of law or it has to be something that's a grievous violation of the standards. But point being, it is a very strict standard, and it is to annul the case, not to appeal certain aspects of it. So the losing party, depending on the reasoning of the award, could request an annulment, but again, that's a very, very high bar, and there's a lot of controversy about whether that can be viewed as a kind of a means for appeal or not. You can also try and set it aside in certain investment arbitration contexts. You can try and set it aside in domestic courts, but again, usually those set-aside statutes have an extremely high bar for really grievous violations of the law by the tribunal.
I just wanted to know, are there any provisions allowing for amendments of these treaties? Because moving forward, you don't know really exactly. This was in the 1990s, so a while ago. We don't know like how much more information we're going to get based on whatever else was signed in those treaties. So is it possible for changed or modified to affect what goes on when more information is found out about something that was signed decades ago?
There's a big movement around this, and it's one, as my intro indicated, I represent states, sovereign states, in treaty disputes with other states and with foreign investors. So we're constantly advising states on a whole spectrum of issues, and one of the things we're advising them on is reassessing, reevaluating the commitments they've entered into in past investment treaties, and also how they would like to approach investment treaties in the future, and establishing a model BIT, for example. So in terms of addressing past treaties, commitments that they've already entered into, there are multiple ways to do this. Can you reform it? The answer is yes. You can, and there are different means of doing so, but basically it comes down to the two state parties who were agreed to these commitments can always reformulate their agreement so long as they're both in agreement. And in the multilateral treaty context, there also is some space for the parties to amend, to clarify the meaning of some of the commitments that they've entered into. And that's a big part of the current movement now that states are aware of some of these issues, of reevaluating how they deal with them, both in past commitment and in future.
I just have a follow-up on that. So the reform process for the BITs, is that something that's very resource intensive for a state to get involved in as well? Would that be a barrier to engaging in that process?
Let me think about that. It can be as intensive or not as a state would like it to be. For some states that are very familiar with investment arbitration, they have in-house counsel who kind of know what they're doing. This is, people devote themselves to this day in and day out, and it's part of their negotiation process. For other states where this is really unfamiliar ground, they have more of an education that they need. And there are multiple ways they can better educate and inform themselves. And that can be a very resource-intensive route, or it can try and take advantage of the less resource-intensive options out there. And one of them is this fund set up by the Gates and Bloomberg Foundation. One of the things they're trying to do, working with others, including firms like my own, is to help educate and inform states in how they can go about doing this.
There's been evidence that the tobacco industry kind of tries to influence, policies or regulations in their favor. Has there been any evidence that have reached out at that level, WTO or?
The WTO, I don't know. The WHO has published reports about the extent of meddling that was involved, both when the FCTC was being negotiated, but also kind of writ large. I'm not aware of evidence of interference. I will say with the WTO dispute that it allows for third-party states, for interested states, to also participate, submit briefs to inform the panels in the dispute. And this case resulted in the highest participation by interested parties in any WTO dispute ever. So it tells you the level of involvement from states pro tobacco control regulations and anti-tobacco, anti these regulations at least. What the factors leading into that are, anyone can say.
Oh, perfect. Okay. So I think we're out of time. I just want to thank our speaker. This is just a fantastic, you presented it so clearly and such an important topic. So thank you so much for coming.
My pleasure.